died on the vine without ever blossoming into a final decision. Second, the Ninth Circuit viewed these drafts as final documents because the drafts largely don't contain redlining, marginal comments, or other obvious signs of still being in flux. That reasoning is unsound. No one would confuse a law clerk's draft with a final decision by a judge, even if
Jones versus Mississippi. Proceeding as it's progressing.
Settled law recognizes the scientific, legal, and moral truth that most children, even those who commit grievous crimes, are capable of redemption. After Miller and Montgomery, there is no denying that the permanent incorrigibility rule is settled law. Only juvenile homicide offenders who are permanently incorrigible may be sentenced to life without parole. A paragraph in Montgomery about formal fact-finding has created confusion, but it cannot mean that no determination of permanent incorrigibility whatsoever is required, because that would obliterate the crux of the decision. Any rule of law requires deciding if the defendant fits within the rule. But Mississippi's courts have denied the permanent incorrigibility rule itself, and the state continues that denial in this court. In remanding this very case for resentencing, the Mississippi Supreme Court did not say a word about the permanent incorrigibility rule and affirmatively misinterpreted the law by stating that LWOP is unconstitutional if and only if the sentencing judge does not consider youth-related circumstances. On remand, the sentencing judge made clear he was weighing aggravators and mitigators, not assessing permanent incorrigibility. Even under an implicit finding rule that usually assumes the judge knows the law and implicitly finds the defendant incorrigible when imposing a life without parole sentence, there is no implicit finding here. That's why Mississippi continues to dispute the permanent incorrigibility rule itself. The court should enforce settled law by remanding for an answer to the decisive question: is Brett Jones, who committed a crime just weeks after turning 15, permanently incorrigible?
Mr. Shapiro, I'm having just a little trouble figuring out what exactly it is that you're looking for. We know it can't be a formal finding, as I think you indicated, because of Miller and Montgomery's statements. And obviously you want more than just a hearing at which you'd have an opportunity to raise the arguments. But what is it in the middle there? Is it just a statement on the record at some point during a hearing? Is it, I don't know, some kind of informal finding? What exactly do you need?
On the most fundamental level, Your Honor, what we need is a sentencing judge who understands that permanent incorrigibility is the dispositive rule and determines whether the defendant fits within that rule. And there are any number of ways that it could be done. One is through words, not magic words, but words, but that convey in substance the idea that the defendant is permanently incorrigible, going to commit more crimes, going to recidivate, etc. And the other, one other is that usually you can presume an implicit finding based on the presumption that the judge knows and implies the law, and therefore that a sentence of life without parole implicitly is a determination of permanent incorrigibility, just not here, because this is within the context of a state system that does not recognize the permanent incorrigibility rule to begin with.
Well, at the hearing that took place here, the irreparable corruption, I guess, was the label they used. That was certainly argued by the counsel. You know, he said you have to distinguish between a juvenile offender whose crime reflects unfortunate yet transient immaturity and the rare offender whose crime reflects irreparable corruption. The judge certainly referred to Miller, said he considered each and every factor that is identifiable in Miller, and concluded that the petitioner was not entitled to the benefit of the leniency provided in Miller. I mean, is the problem really just that the judge didn't quote enough passages from Miller? He certainly cited it.
No, Your Honor, that's not the problem. The fundamental problem is that the judge does not appear to have understood that permanent incorrigibility is the decisive rule that he needed to apply. And in fact, in remanding the case, the Mississippi Supreme Court said that the sentence is unlawful if and only if the judge does not consider youth-related factors. And that was an affirmative misstatement of the law. And then the judge said that he was weighing aggravators and mitigators rather than making an assessment of permanent incorrigibility. This is not about a formal declaration. It is about a judge correctly applying the settled rule that this court has laid down.
Well, the evidence of what he said at the hearing, I think it's not a finding of a historical fact. And you talk about things like intellectual disability and the like. The permanent incorrigibility strikes me as different. It's more a judgment rather than a specific fact. And from that perspective, I'm just not sure what he said isn't enough.
This court has made it clear that permanent incorrigibility is incapacity for rehabilitation. And there is no way I see on the record to conclude that the judge made a conclusion about that, not a finding or even some kind of predictive judgment. And again, he was operating under instructions that affirmatively said he didn't have to make that bottom line determination. He only needed to consider factors, and as long as he did so, the sentence was constitutional.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. Counsel, following up on the Chief Justice's line of questioning, what if the judge did exactly what you said was required and stated on the record that there had to be a finding of permanent incorrigibility and went on to do exactly what was done here? Wouldn't it be implicit in that sentencing that he made, that the judge made the finding of permanent incorrigibility?
Yes, I think so. In this case, for the judge to have said that, it would have been contradicting the instructions that were given by the Mississippi Supreme Court in remanding the case, which said that all you have to do is consider youth-related factors. But the statement that Your Honor just alluded to would make it very clear that the judge understood that he needed to determine permanent incorrigibility, and then the sentence of life without parole would implicitly reflect that determination. It would be an implicit finding.
Would you, and I'm just curious here, would you be able to make your argument had we not decided Montgomery?
Yes, Your Honor, I believe so. It is certainly, yes, it is certainly true that Montgomery made the rule clearer, the permanent incorrigibility rule in interpreting and construing Miller. And it's important to note that one of the reasons that you can't presume an implicit understanding of Montgomery in this case is that the judge issued the sentence before Montgomery was issued. But Miller itself does say on pages 479 to 480 that the judge has to distinguish between irreparable corruption and transient immaturity, and then Montgomery repeats that 7 times as an indispensable part of its conclusion that Miller is retroactive.
But did Miller, on its face, without the gloss of Montgomery, did it actually say that a certain finding or a certain procedure was required?
It did not say that a certain finding was required. It did say that there has to be, the judge has to distinguish the transiently immature from the irreparably corrupt. And the only way for that to happen, one must infer, is the court has to decide which side of the line the defendant is on. And that could be an implicit determination. It can be a more explicit one. But you have to know that the judge properly understood the rule and decided whether the defendant fit within it. Ordinarily, you can presume that the judge knows and correctly applies the law, but that presumption does not apply here because of the affirmative misstatements of the law that I've alluded to.
I'd like one more try at a world without Montgomery. Would you tell me whether or not you think, without, again, the gloss Montgomery, you think that Miller is a substantive rule or a procedural rule? And if you think it is substance, again, without the gloss of Montgomery, give me an indication of why you think that.
I think that it is a substantive rule that only permanently incorrigible juveniles can be sentenced to life without parole. I think that because the court says on 479 to 480 of Miller that there has to be a distinguishing between the transiently immature and the irreparably corrupt. And I also contend that it follows as a procedural consequence of that substantive permanent incorrigibility rule that the judge has to determine whether the defendant is permanently incorrigible.
Thank you.
Justice Breyer?
I would follow up on Justice Thomas and just say, what if you were writing the opinion for the court in this case, how would you put it? Say, first part I think is fairly easy. You say, in Miller, we decided you can only sentence, cannot sentence a juvenile to life without parole unless he is permanently incorrigible. The state has leeway to decide the procedure through which this decision will be made, and now what?
Yes, Your Honor. I would write the decision, to answer the question, to say that the court has to resolve whether or not the defendant is permanently incorrigible in order to impose the sentence, and that there are different ways to tell if the judge resolved that question. One is words that convey in substance, not magic words, but words that convey in substance that the defendant is going to commit more crimes or can't be rehabilitated. The second, and the court has options here. We think that that is the better rule that requires some sort of explicit statement, not magic words, but given the gravity of the constitutional interest or the deprivation that's occurring here, we think that is the better rule. The other option that the court has is to say that there is an implicit finding rule, that ordinarily you presume that the judge understands the law, understands the permanent incorrigibility rule, and that the life without parole sentence reflects a determination that the defendant is permanently incorrigible, but that presumption doesn't apply here because of the affirmative misstatements that I've alluded to. And either way, the court could make it clear that there is plenty of room for state experimentation and innovation as to the procedure, as to who bears the burden, what is the standard of proof, what is the standard of review, et cetera. But the one thing it has to do is resolve the question of permanent incorrigibility.
Thank you.
Justice Alito?
Good morning, Mr. Shapiro. If you have it in front of you, could you just repeat the first sentence of your presentation this morning?
Yes, Your Honor. The first sentence was, settled law recognizes the scientific, legal, and moral truth that most children, even those who commit grievous crimes, are capable of redemption.
Yeah, I think you are. This is fascinating. You want to take us, and you want us to take the courts of this country into very deep theological and psychological waters. Do you think that there are any human beings who are not capable of redemption?
Well, Your Honor, I think that there are many psychologists who can very much testify and do testify that particular individuals are permanently incorrigible and can't be rehabilitated. And in fact, as we speak, courts across the country are resolving the question of permanent incorrigibility.
There are a lot of people, they're not psychologists maybe, but there are a lot of people who think that every human being is capable of redemption. There's actually a famous quote by Gandhi who says exactly that. There are a lot of Christians who believe that. You think of the good thief on the cross. So what if a judge says, wow, the Supreme Court says I have to determine whether this person is capable of redemption. I believe that every human being is capable of redemption. What do you do with that?
I think the inquiry is capacity for rehabilitation. And I think that the judge needs to do what every judge does and is doing in these cases, which is to hear evidence, evidence of criminal record before and after the crime, testimony about the perpetrator. The crime itself is very much relevant, and to make a determination as to whether the defendant is going to recidivate or has the capacity to be rehabilitated and not to recidivate. It's not a theological conception. It is a determination of whether the defendant has the capacity to rehabilitate and not recidivate. And if in the event that the judge does make an error and the person's capacity for rehabilitation is not realized, they're never getting out. They're dying in prison anyway, because the ultimate decision is made by the parole board as to whether release actually occurs.
Now, you read both Miller and Montgomery very broadly, and there certainly is some language in both opinions that you are able to cite. But if we look strictly at the holdings in those cases, what Miller held, and this is what it said expressly, we therefore hold that the Eighth Amendment forbids a sentencing scheme that mandates life in prison without the possibility of parole for juvenile offenders. And what Montgomery said was, we hold that Miller set out a substantive rule, and what followed from that was that it was retroactive. So if we just follow the holdings of those cases, we get to a much narrower rule of law than the one that you're proposing. Isn't that the case?
No, Your Honor, and that's because the holding of a case includes the indispensable reasoning. The only reason that Montgomery held that Miller was substantive and thus retroactive is that it set out a substantive rule that only permanently incorrigible juveniles can be sentenced to life without parole. And
let me ask you just one more question before my time has expired. What would you say to any members of this court who are concerned that we have now gotten light years away from the original meaning of the Eighth Amendment and who are reluctant to go any further on this travel into space?
I don't think this goes any further, Your Honor. This is just the court has laid down a permanent incorrigibility rule, stated it in Miller, restated it 7 times in Montgomery as an indispensable part of this whole of the holding and the conclusion, and simply saying that a court has to decide whether a defendant fits within a rule of law already laid down by this court is no journey at all.
All right, thank you very much.
Justice Sotomayor?
Counsel, in your cert petition and in your briefing, you framed the question presented as a narrow one about the need for an express finding of permanent incorrigibility. You did not seek cert on the question of what other procedures Miller might require, correct?
I think Your Honor said express finding of permanent incorrigibility, and that is not in the question presented. It says finding, and it's really my friends on the other side who are trying to load up the case with affirmative, express, explicit.
So if you understand that Miller, because it said it, didn't require an express finding, in sentencing, for example, in regular sentencing, a district court judge says, I've considered the factors in 3553A, and this is the sentence that I think is adequate. And we say that's enough. Here the judge said, I've considered Miller and all of the factors it talks about, and it's just been told that one of them, most importantly, is incorrigibility. And I don't see the state in that transcript arguing otherwise, meaning that incorrigibility is not significant. In fact, they addressed it and made the argument he was incorrigible. So under those circumstances, why isn't that the beginning and end of this case, i.e., the judge made an adequate finding under Miller?
The reason, Your Honor, is that in remanding the case, the Mississippi Supreme Court said all you have to do is consider factors, and as long as you consider factors, the sentence is constitutional.
But the judge went further and said, I'm considering the Miller factors, not the state factors.
Yes, considering the Miller factors without treating capacity for rehabilitation, permanent incorrigibility, as the dispositive rule is not sufficient.
Well, then you're getting back to you want magic words, because I don't see how this is any different than a regular sentencing where a judge says, I've considered the 3553 factors. We don't question whether they did it or didn't do it. We take them at their word. And that was the entire argument at the sentencing.
In the federal sentencing context, Your Honor, it is usually the case that you presume, even though the judge doesn't say it in most cases, that she is imposing the minimum sufficient sentence. That is just implicit. And the reason it's implicit is that one assumes that the judge correctly understands the law. But what happened in this case was that the Mississippi Supreme Court said all you have to do is consider these factors. Considering the Miller factors is not the same, this is a critical point, is not the same as a bottom line determination of permanent incorrigibility. It would not be sufficient in an Atkins case, for example, for the judge to consider intellectual disability, but then decide that the defendant's intellectual disability was outweighed by some other factor. And it's not sufficient just to consider the Miller factors without a bottom line determination of the eligibility rule, whether the defendant is capable of rehabilitation or permanently incorrigible.
Thank you, counsel.
Justice Kagan?
Mr. Shapiro, what you just said is exactly what I want to ask you about, because your argument is that Miller and Montgomery set out not just a process, not just a rule that youth has to be considered, but instead a substantive rule that you can give an LWOP sentence only to a small category of people, call them the irredeemables or the incorrigibles or what have you. And the government in Mississippi contest that understanding. And I want to get your reaction to their arguments. What the government says is that all this talk about incorrigibles, that's just really a label for the final judgment that a court reaches after it considers youth during sentencing. And what Mississippi says, in addition, is it says that the whole point of Miller was just to prevent against the excessive risk of disproportionate punishment, but that the essence of it is a procedural requirement about considering youth. So why aren't they right?
The reason they're not right, Your Honor, is one, that Montgomery says something very different, and two, that it could not have said what they contend and arrived at the conclusion that Miller is substantive and thus retroactive. Montgomery reiterates 7 times as an indispensable part of its conclusion that there is a substantive and thus retroactive rule. What that substantive rule is. That substantive rule is that only permanently incorrigible juveniles can be sentenced to life without parole. And simply considering a group of factors or the Miller factors, as they've sometimes been called, that is a procedural undertaking. Because whether you arrive at a life without parole sentence through a mandatory procedural route or through a discretionary procedural route, that is a procedural question. The substance of the sentence is life without parole, and merely considering factors does not fit within either of the Teague substantive rule categories. It doesn't make certain primary conduct not criminal, and it does not take a sentence off the table for a class of people. The only thing that does that is exactly what Montgomery says, which is that only permanently incorrigible juveniles can be sentenced to life without parole.
And Mr. Shapiro, this goes back to a question that Justice Thomas asked you. But let's assume that you're right about what Montgomery says. And as you say, Montgomery said it not 1 time or 2 times or 3 times, but like something like 7 or 8 times. But suppose you think that that's an aggressive reading of Miller. That although you said, on page 479, Miller says this, that wasn't really the thrust of Miller, and in fact, Montgomery, read it quite aggressively, and that there's a gap between the two. If that's right, I mean, you can first tell me whether you think that's right, but if it's right, which opinion should we look to and why?
Yes, Your Honor. And so to the first part, I mean, the language on 479 to 480 of Miller says, it speaks of the distinction between the juvenile offender whose crime reflects unfortunate yet transient immaturity and the rare juvenile offender whose crime reflects irreparable corruption. And then it says, although we do not foreclose a sentencer's ability to make that judgment referring to the previous sentence and the distinction between the two classes, although we do not foreclose a sentencer's ability to make that judgment in homicide cases, we require it to take into account how children are different. I don't think there's any way to read that as optional. The court has to distinguish under Miller between the permanently incorrigible and the transiently immature. As to the second part of the question, this court's construction of its own precedent is authoritative and becomes part of the edifice of stare decisis. And so Montgomery's construction of Miller is absolutely entitled to stare decisis deference, and to deny that is to imperil the interest in the stability of the law that stare decisis is designed to.
Thank you, Mr. Shapiro.
Justice Gorsuch?
Good morning, counsel. I'd actually like to pick up more or less where you left off with Justice Kagan. Let's assume for the moment that we might view Miller as a procedural requirement and a modest one, and Montgomery is significantly expanding and maybe creating a new substantive right during the process of purportedly doing the Teague analysis. What do we do with that? I mean, if it did create a new right, and just work with me on that assumption and a new substantive right, wouldn't we need then a subsequent decision deciding whether that new right should be retroactively applied under the Teague plurality analysis?
As to whether it should be retroactively applied, I do want to first stress, Justice Gorsuch, that this case is on direct review. Of course, it's different than the Malvo case that was on collateral.
No, I understand that, and I've got questions for your colleague coming up next on that. But if you could just stick with my question for the moment.
Yes, Your Honor. It's not unheard of, certainly, for the court to construe and interpret precedent in a subsequent case, including cases on including cases even on collateral review. Unlike this case, I mean, take the Hall case, which was on collateral review, interpreting the Atkins requirement.
But it is a little unusual in the name of purportedly deciding the retroactivity question under Teague to then create a new right and then not consider whether it should be applied retroactively. It's a little bit of an anomaly, which maybe raises for me the next question. What about Teague? I mean, we've been applying this plurality opinion from Teague for some time, watershed rules of criminal procedure, we've never found one, and substantive constitutional rules, and we wind up turning a procedural rule into a substantive rule in order to have it have retroactive effect. You know, it kind of brings to mind Justice Jackson and Brown versus Allen. You know, second guessing all these state final judgments. From original matter at least, what authority do we have to be reconsidering state final judgments in this way?
Well, the first thing I want to stress in response to that question is that this is the majority rule applied, to the vast majority of states. It's really Mississippi that is an outlier in refusing. But to answer the question, Justice Gorsuch, there is, of course, a very long line of cases establishing that this court does have authority to review state court decisions retroactively. But again, in this case, which isn't on collateral review at all, I don't think that it bears a direct relation here.
Thank you, counsel.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Mr. Shapiro. You started today by referring to settled law, but then you said that the paragraph in Montgomery had created confusion. But the paragraph in Montgomery is part of the law, of course, and I guess I'm not seeing it as all that confusing, at least on its own. I know your Teague point, but on its own, it seems very clear in saying multiple times in that paragraph that a finding of fact about incorrigibility is not required. First question, do you agree that a finding of fact regarding incorrigibility is not required?
No, because that paragraph is referring to a formal finding, and I know that it doesn't use that word throughout the entire paragraph, but I do think it is clear from the paragraph that the court is talking about one thing and not jumping around between different types of finding, and so the modifier formal, a formal finding is what the court is referring to in that paragraph.
But doesn't, you noted this, but it does not use the word formal at least the first two times it's used, and I'd be curious what the distinction between a formal finding of fact and an informal finding of fact might be in this serious context.
Yes. As to the first part of the question, I think the specific controls the general, and the court should look to the phrase that provides more information about what the court is talking about in that paragraph rather than less information, and that phrase is formal fact-finding. And I think that what a formal fact-finding might even require some kind of particular verbiage or heightened explicitness or formality. And what we are saying is that that would certainly be sufficient to satisfy the Eighth Amendment, but also in the ordinary course, you can have the sort of implicit finding where you presume the judge knows the law and that a sentence of permanent incorrigibility implicitly reflects that a sentence of life without parole implicitly reflects a determination of permanent incorrigibility.
Okay, so let me ask you this. When the sentencing scheme is discretionary, won't the judge necessarily consider youth, and in particular because defense counsel will invariably raise the defendant's youth as a reason not to impose life without parole, and even apart from that, that will be the common sense of the situation when you're dealing with someone who committed a crime at 15, as we have here, that you'll be considering that. That'll really be the centerpiece, you would think, in most cases. So when the judge then determines that the sentence should be life without parole, won't the judge necessarily have made that informal finding or that judgment or that conclusion that you're seeking?
A couple of points, Your Honor. The first is it's not enough just to consider the fact that the defendant is young or to consider youth. The question, the substantive rule of permanent incorrigibility has to be answered, has to be resolved. And in this case, the judge didn't resolve it, not implicitly, not explicitly, because he said he was just weighing aggravators and mitigators, and the state court system does not recognize that permanent incorrigibility is an eligibility rule that has to be resolved.
Okay, and by analogy to the death penalty mitigating circumstances context, there, as you know, the court over many years has required consideration of mitigating circumstances, but in that context does not require any particular finding of fact or any particular conclusion. It leaves it to the sentencer to make that judgment based on consideration of all the circumstances. I'm putting aside for the moment the requirement that there be one aggravating circumstance, but beyond that, there's no particular finding necessary. Isn't that a similar situation to what we have here?
That's not the case when it is an eligibility rule like we have here, when it is like the Atkins eligibility rule based on intellectual disability or the Ford eligibility rule based on insanity. In those cases, the court requires a determination. It may not be a formal finding, and again, that is not what we are saying is required here, but the judge has to determine whether the defendant fits within the class that can be subjected to the punishment.
Okay, my time's up. I'm sorry, Mr. Shapiro. Thank you.
Justice Barrett?
Good morning, Mr. Shapiro. I have a question about an as-applied Eighth Amendment challenge here. I take it that you think that Mr. Jones can bring such a challenge.
I do, yes.
Then why isn't that the primary protection? You know, if the judge applies the wrong factors, as you say happened here, why isn't then the case that he's better off not challenging the procedure, but simply directly challenging the substantive decision that he's permanently incorrigible?
In order to challenge the substantive procedure that he's permanently incorrigible, he needs to be proceeding in front of a judge who understands that permanent incorrigibility is the dispositive rule. And here the judge didn't understand that that was what he had to decide. And so I absolutely believe that Brett substantively is not permanently incorrigible. His grandmother, the wife of the victim, testified on his behalf. A correctional officer spoke of his rehabilitation, his extraordinary record in prison, how he is an incredible worker and tries to get along with everyone. And beginning from a kid who had just turned 15 and who committed a murder for the most immature reason possible, teenage infatuation, there is an extraordinary story here showing that Brett is an individual who is fully capable of rehabilitation. But because that wasn't even treated as the substantive rule, that's not what the determination that the judge was making was about.
But then why can't you appeal that? Why can't you then, you know, if you argued below that he was not permanently incorrigible, and essentially, you know, one way of looking at what the trial court did is did not make a finding, did not say he was permanently incorrigible, and you're saying as a matter, this is a violation of the Eighth Amendment then to sentence him to life without parole, why can't you just raise that challenge, you've preserved it, and raise it on appeal?
We did, Your Honor, but the problem is that the Mississippi courts don't recognize that permanent incorrigibility is a rule. So just saying that and showing that your client is capable of rehabilitation isn't sufficient to demonstrate that the sentence is off limits for him. And that's the very problem in this case. There's just no determination that the rule that is actually the rule applies to my client.
But let me just interrupt you then. If it's clear in the cases, or if we make clear in this case that it violates the Eighth Amendment to sentence a juvenile to life without parole if that juvenile is not permanently incorrigible, then the law is clear. And I guess I still don't understand. Or let's talk about collateral review. You know, if this goes to a federal court on 2254 and there is no factual finding for the federal court to defer to, and the law has been misapplied, what about that? Then can you get relief on collateral review?
To answer the first part of your question, Your Honor, yes, going forward, absent extraordinary evidence to the contrary, like I'm going to sentence you, I don't care what the Supreme Court says, yes, you absolutely would be able to presume, absent evidence to the contrary, that the judge correctly understands the law and that the sentence reflects an implicit finding of permanent incorrigibility. As to the collateral review context, this is a substantive rule, a permanent incorrigibility rule, going all the way back to Miller. It is the majority rule among the states, and in large part, the statutes of limitation have run.
Thank you.
Mr. Shapiro, do you want to take a minute to wrap up?
Thank you, Mr. Chief Justice. Mississippi and its courts do not recognize the permanent incorrigibility rule. In this very case, the state Supreme Court's remand opinion did not mention that rule and instead said that a life without parole sentence is lawful so long as the sentencing court considers youth-related factors. Brett never really had a chance to show that he wasn't permanently incorrigible in any kind of meaningful way because the court had been told that it doesn't need to resolve that question against him in order to sentence him to life without parole. And to allow the permanent incorrigibility rule to be flouted is to discard Miller and Montgomery and to undermine stare decisis and the interest in stability that it protects. This court does not announce rules for them to be ignored. So whatever form the determination should take, Mississippi's courts need to answer the question they have evaded: is Brett Jones permanently incorrigible? Thank you.
Thank you, counsel. Ms. Noble?
Mr. Chief Justice, and may it please the court. In 2013, Jones's mandatory life without parole sentence for the brutal murder of his grandfather was set aside after the Mississippi Supreme Court held that Miller versus Alabama announced a substantive rule of constitutional law prior to this court holding the same in Montgomery versus Louisiana. Miller held that mandatory juvenile life without parole sentences are unconstitutional because they pose too great a risk of disproportionate punishment. The constitutional flaw in such mandatory schemes is that they make youth and all that accompanies it irrelevant. To address that flaw, sentencers must consider how youth and its attendant characteristics may diminish the penological justifications for punishment before imposing a life without parole sentence. After Miller, Petitioner Jones received an individualized sentencing hearing where the sentencing court considered the mitigating circumstances of Jones's youth and its attendant characteristics before exercising discretion to impose a life without parole sentence. Jones received what this court and the Eighth Amendment requires. Jones now contends that his sentence is still unconstitutional because the sentencing court did not also make a finding that Jones is permanently incorrigible, but that premise is wrong for three main reasons. Miller implicitly holds, and Montgomery explicitly states, that a finding of incorrigibility isn't required. Second, the individualized sentencing line of cases on which Miller relied demonstrates why Jones's position is unavailing. And lastly, whether a crime reflects permanent incorrigibility or transient immaturity isn't a separate inquiry apart from the consideration of youth. Instead, this court has used such terminology descriptively as a way to describe a crime, the circumstances of which either do or do not make a life without parole sentence grossly disproportionate. And as this court explained in Kansas versus Carr, whether mitigating circumstances exist to sufficiently warrant a lesser sentence is a judgment call, or perhaps a value call. That is, it is a normative judgment reached after Miller's evaluative process. That process was followed.
Counsel, I asked Mr. Shapiro starting out what exactly it was he was looking for, and I have to say it didn't seem like very much. I think one sentence sort of articulating the holding of Miller and another sentence saying that's what I've determined or that's what I find. As I understand him anyway, I think that would be enough. Why isn't that acceptable to the state? If the question is, have they applied Miller, just a sentence saying they have, as Justice Sotomayor said, sentencing judges all the time refer to what findings are required, and we don't question their statements that they've considered those.
I think the primary disagreement that we have with Petitioner Jones's argument is he continuously relates this to Atkins and Ford, that permanent incorrigibility really in the abstract is an objective type of a fact, and it isn't. It is a way to describe what is a grossly disproportionate sentence. This court always anchors whether or not something is permanently incorrigible to whether or not the crime reflects it. And so I think you can... Well,
if you look at the transcript of the hearing, it seems to me that what the judge is doing is the kind of sentencing weighing of considering a variety of factors. I mean, I think he says that, you know, the factors in Miller, the Miller factors. It doesn't sound like the consideration of a specific direction from Miller.
I think Miller goes a long way to answering and does answer this question. On page 473, the court tells sentencers what they must do and why they must do it. They must consider the way mitigating circumstances of youth may weaken the rationales for punishment. That is exactly what the court did here, and that's what our trial courts are used to doing. They consider mitigating circumstances and try to determine whether or not all of the circumstances would make a lesser sentence appropriate.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. Counsel, Do you think that you can reconcile Montgomery and Miller?
I think that we have tried in good faith to reconcile both of them and to not quarrel with either of the decisions. Again, Mississippi found Miller announced a substantive rule 3 years prior to this court. And I think the way to do that is this. I think the substantive right at issue in Miller is the protection against grossly disproportionate punishments. The question then becomes, what is the process Miller prescribes for reducing the risk of a grossly disproportionate? And it isn't by wordsmithing a sentencing transcript or fly-specking them after the fact. It's by individualized sentencing. So what Miller adds to gross disproportionality is the consideration of youth. And if you read page 734 of Montgomery, which petitioners cite often, to simply describe grossly disproportionate punishments, I think they can be reconciled. And I think you can see this because the court vacillates between various adjectives. Crime reflects permanent incorrigibility. Crime reflects irreparable corruption. Crime reflects transient immaturity, which shows that the court is using these terms as a shorthand descriptor, as does the fact that the court rejects the notion that a finding of incorrigibility is required on page 735.
So how would it, other than the fact that it would not have been retroactive if Montgomery had not been decided, if Montgomery was not on the books, how would you apply? Would Miller have changed your procedures much?
No, Your Honor. If I'm understanding the question correctly, that the state would have been applying Miller, it certainly changed the procedures after Miller, because Mississippi, as determined by the Mississippi Supreme Court in Parker versus State, said that the state had a mandatory sentencing scheme. And so now the state has done what Miller requires. And really, I think our bottom line conclusion, you can look at it this way, is that the 15 jurisdictions that Miller kind of highlights as what is constitutional, for example, in footnote 10, none of them required a finding of permanent incorrigibility. So what we're saying is that the constitutional regimes Miller said are constitutional are indeed constitutional, and Mississippi is in line with those regimes.
Thank you.
Justice Breyer?
Well, it seems to me now there are two questions. Does Miller, after Montgomery, say that in order to sentence a juvenile to life without parole, he must be incorrigible, all right, permanently incorrigible? Did the court say that? I think yes, okay? So assume I'm right on that. Yes, that's a substantive rule. But then my question is the same as Justice Barrett's. Why isn't that the end of the case? Judges do decide substantive rules all the time. And the question is, well, did they get the rule right? And so if the lawyer tells the judge the rule, and maybe he's inadequate if he doesn't, and then the judge starts talking about balancing factors, and then the Supreme Court starts talking about balancing factors in that state, well, they haven't got the law right, substantive law. And the same thing happens. You do it again under the right law. End of case. Now, does that, what's wrong with what I just said?
Well, I think the beginning of the proposition that permanent incorrigibility somehow, in the abstract, not anchored to the crime, somehow became a substantive rule.
I'm sorry, I know that you disagreed with that, and so I asked you to assume that. Assume that I'm right on that.
If Your Honor is right on that, then I would still say that the substantive law here was applied correctly, because what we are concerned about, even in the permanent incorrigibility type of a context, is a grossly disproportionate sentence. And
then you're remaking. I'm sorry to interrupt you, but what I'm interested in is on the assumption there's an absolute rule. No incorrigibility, no life without parole. Okay? Absolute rule. Now, can we say, state, you enforce that rule just like you enforce any other rule of law? You go look at what the judge said, you go look at the conditions, and you say, did he have the law right in his mind when he did that? And however Mississippi chooses to do that within the realm of reason, that's up to Mississippi.
I agree at that point that the procedure to enforce the rule would at that point be up to Mississippi, and here I do think it was argued specifically, if you look on Joint Appendix 144, specifically Jones's argument was that transient immaturity, quote, quite likely was involved here, and the judge rejected that. So I think what we're arguing over here is more of a procedural issue, but if that is a substantive issue, Mississippi applied it, and the judge rejected the argument.
Justice Alito?
Counsel, my problems with this case go a lot deeper than these procedural questions that have rightly occupied, have occupied most of the argument. I don't really understand exactly what we are talking about. There are a lot of statements in Miller and Montgomery, and one of them, which a lot of the argument has focused on, is the statement that a judge has to determine whether a particular defendant's crime, a particular minor's crime, reflects transient immaturity or incorrigibility, as if those are the opposite sides of the same coin, but they're not. A crime could reflect transient. A crime could reflect transient immaturity. A minor could be completely mature and yet capable of being rehabilitated. So what are we talking about? And keep in mind that of the three purposes of punishment that the court identified and applied in Miller and Montgomery, the first, which is retribution, has nothing whatsoever to do with rehabilitation.
I think the best way Montgomery puts it is on page 734. And that's that Miller requires a sentencer to consider a juvenile's youth and its attendant characteristics before determining that a life without parole is a proportionate sentence. So if you look at the substantive right being the protection against grossly disproportionate, the way we understand page 734 of Montgomery is to say that a crime reflects transient immaturity. That simply describes a crime the circumstances of which make a life without parole grossly disproportionate. But Miller is an all things considered type of an analysis. It's not a myopic focus on one particular fact. One particular fact and one particular piece of evidence is not going to ipso facto make a life without parole either proper or improper. It truly is a all things considered and see if mitigating circumstances are going to diminish all of the penological justifications for the punishment. I think that's
all right. Thank you, counsel.
Justice Sotomayor?
Counsel, Montgomery says repeatedly on 734 and in other places that Miller did more than require a sentencer to consider a juvenile offender's youth before life without parole. So merely considering youth can't be enough under Montgomery. It established that the penological justification for life without parole collapsed in light of the distinctive attributes of youth. More than once it says, even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. Proportionality of sentencing looks at the nature of the crime, but Miller and Montgomery made very clear that we're looking at the nature of the offender. So is it your position that if a sentencing court says, I've considered the Miller factors, but I think the crime does not reflect permanent incorrigibility, but I'm going to sentence him to LWOP anyway because the crime was really horrific?
Not if you understand a crime that reflects transient immaturity simply to describe a crime, the circumstances of which make a life without parole grossly disproportionate. And if I can, I would like to take the two sentences.
But how do you, counsel, but that would mean most would be, because Montgomery says it's the rare juvenile offender whose crime reflects irreparable corruption. Multiple times in Miller and in Montgomery, the court says it should be rare.
I I agree with that, Your Honor, and I think the best way to read that is to say that this court, looking at the whole, for example, it looks at statistics on footnote 10, was envisioning that many times the mitigating circumstances of youth and all the surrounding circumstances would indeed make a life without parole sentence grossly disproportionate.
So if a judge said what I said, he's not permanently incorrigible, but I think the crime is serious, would that violate Miller and Montgomery in your view?
Your Honor, I may be misunderstanding, but I think I look at those two questions a little bit differently.
I know you don't, but answer mine. If a judge says this is not a permanently incorrigible human person.
Yes, if this court is using permanently incorrigible, not anchored from the crime, perhaps so. Perhaps a life without parole judgment would be proportionate. I don't think corrigibility is some discrete objective fact in the abstract about a person, and that is why the court time again anchors it to what a crime reflects. Can the crime be sufficiently diminished by or explained by some quality of youth? And again, nor do I think that—
Thank you, counsel. Justice Kagan?
Ms. Noble, I guess what I'm struggling with here is how, on your theory, we could have labeled Miller a substantive rule in Montgomery. Because I always thought that a substantive rule under Teague meant that there was a class of people who you couldn't, you either couldn't criminalize their conduct or you couldn't sentence them to a certain way. But that was the question, that there was a class of people for whom a particular punishment was impermissible. And you are saying that that's not what Montgomery does. But if it's not what Montgomery does, if Montgomery is only basically ensuring that a certain kind of process is accomplished, then how could Montgomery say that Miller was retroactive?
Two ways. First, Miller is substantive because it is premised on the protection against grossly disproportionate punishment, that there was a grave risk that a life without parole sentence would be grossly disproportionate in any given case. Miller says that on page 470.
And if I could just interrupt you there, Ms. Noble, do you mean to say that it satisfies Teague if there's a process rule that has an effect on substantive outcomes?
I think that the key portion of Miller is that there was a grave risk of a disproportionate sentence. So if you look at page 731 or 733 of Montgomery, it says, quote, protection against disproportionate punishment goes far beyond the manner of determining a defendant's sentence. But the class issue—
again, I guess what you're saying is that there's a process rule, and that process is necessary to prevent a serious potential for bad substantive outcomes, then that's enough under Teague. Is that correct?
Well, what Montgomery says is that there is a grave risk, not a quote-unquote likelihood or a quote-unquote possibility. You can see that on page 736. And so I think if you look at the class language in Montgomery, I'm not disagreeing with Your Honor that that language is in there, of course, but you can look at it, for example, as a numerator-denominator kind of a setup, the denominator being all juveniles convicted of homicide and the numerator being a class of defendants for which a life without parole sentence based on all the circumstances will be disproportionate. My point is that you cannot—
Justice Gorsuch?
Counsel, I'd like to pick up Justice Kagan's question. And before I do, let me just ask one quick question. Because Mr. Jones is on direct appeal from resentencing, do you think he needs the right he seeks to be retroactively applicable under Teague, or is that just neither here nor there?
No, Your Honor. The state has never actually argued that he was on on collateral review.
Okay. So we're on direct review, and we're just trying to figure out what to do with. Let's say we think that Miller was a decision about processes, and that Montgomery did what Justice Kagan described and created a class of persons, or a substantive right for a class of persons. What do we do about that? If Montgomery misstated the rule from Miller, how do we proceed?
of course, don't agree that Montgomery set a new rule, but here's where I think you proceed. I think you look at the process that Miller itself prescribes, because that process is going to effectuate a substantive rule. I don't think Miller and Montgomery read together could be said that the substantive rule that came out of one doesn't match the procedure. I think the process in Miller, which is repeated at least twice in Montgomery, would give effect to any substantive rule, whether or not this court looks at that substantive rule coming from Miller or Montgomery.
Well, but that's not normally how we think of rights. We think of some rights as process rights, regardless of what the substantive outcome. And a substantive right, you have a right to a substantively reasonable sentence, for example, no matter what the process was that led to it. They're independent. They're complementary, to be sure, but one could be violated without the other. So that's normally how we think about it. And I guess I think you're asking me basically to ignore the substantive aspects of Montgomery and just acknowledge that it misread Miller. Am I wrong about that?
I actually think I'm trying to reconcile the two. And so what Justice Kagan was asking about the class of offenders, I think a point that I may not have finished or explained accurately is that there is going to be a class of offenders for which a life without parole sentence will be grossly disproportionate. The point is that you can't define that class categorically, and I don't think Montgomery ever says you can, and I think that would just fall out of step with individualized sentencing to begin with. So I'm not disagreeing that there's going to be a class. I'm disagreeing that there's going to be a class that you can determine categorically. Instead, it's going to be a case-by-case basis on whether or not the mitigating circumstances and all the surrounding circumstances diminish the penological justifications for
Thank you, counsel. Thank you.
Justice Kavanaugh?
Good morning, Ms. Noble. Mr. Shapiro said we shouldn't analogize this situation to Lockett in the death penalty context, but rather to Atkins and Ford, and consider this, in essence, an eligibility requirement with a finding of some kind, not just a process that considers youth as a factor. And that raises, of course, the tension that Justice Kagan was identifying in Montgomery, and I think what she was getting at is that the key paragraph in Montgomery that says no finding of fact is required is, some would say, in tension with the conclusion that Miller was a substantive rule, okay? And so if that's true, and you've made an attempt to reconcile it, and I think you make a good point on that, but suppose that's true, and we either have to follow the paragraph in Montgomery or follow the implication of the Teague conclusion, really say that paragraph is wrong in Montgomery, or back away from it, which Justice Gorsuch was getting at. A long lead up to a bottom line question. Why shouldn't we just require a finding of fact that the defendant is permanently incorrigible?
I think that that's fairly illusory. I mean, a finding of fact that the defendant is incorrigible ignores much of Miller. It's also not an objective fact. It's going to be some type of judgment that a sentencer is going to have to make, and to get to that judgment, you're going to need an evaluative process, and you're going to need to evaluate mitigating circumstances, which this court has always said is a normative type of a value call. And so I think this is more like the Woodson line of cases, and I think we know that because Miller says that. And I think if you really look at petitioner's reply brief on pages 11 and 12, I think it underscores the absence of any constitutional mooring for the rule that the petitioner advances, because he doesn't really tell us, is this a legal rule or a factual rule? Which side would have the burden of proof? Does a judge or jury have to make the finding? If it is a specific finding, does a jury have to make it? And at that point, are we in the Apprendi arena? So I think that just suggests that we don't really know what the nature of the rule is, which suggests that it's probably not a constitutional rule. And we typically don't think about the Eighth Amendment as requiring specific findings. I think that's been completely rejected by this court in the cases that Miller cited, including Johnson versus Texas.
Thank you.
Justice Barrett?
Ms. Noble, do you agree that a defendant can bring an as-applied Eighth Amendment challenge to a juvenile sentence of life without parole?
Yes, Your Honor, that there would be a gross disproportionality challenge. I think what I see Miller adding to gross disproportionality is the consideration of youth.
And what would the standard be? Not permanent incorrigibility, I take it. Just the more broad question of, was this grossly disproportionate?
Yes, I think so, Your Honor, and I think looking at it that way dovetails quite nicely into why Miller is a substantive rule and why Montgomery said Miller was a substantive rule, because you're trying to, in Montgomery's own words on page 734, you're trying to determine that a life without parole is a proportionate sentence.
But how do you determine that if you're not looking at the question of whether this is transient immaturity or a reflection of permanent incorrigibility? How is the appellate court what standard is it supposed to apply?
I think that Miller considers an all things type of an analysis and weighing mitigating circumstances. That's something trial courts do using the tools and the rules that trial courts normally do. I think the way we define a crime as to whether or not a crime reflects transient immaturity is a crime sufficiently mitigated by the distinctive characteristics of youth so that all the circumstances surrounding the crime would make a life without parole grossly disproportionate. I mean, can you explain this crime by a particular quality of youth? It's always anchored to the crime, and I think that makes sense because in going forward with these Miller cases, you're not going to have any evidence of post-sentencing rehabilitation.
Won't you often be able to say that? I mean, and I guess what I'm wondering is then, aren't we back to whether it's procedural, just youth matters, and we see that the trial court considered youth?
I do think that that is the procedure, but I think the substantive component and what Miller and Montgomery were concerned about is that not applying Miller retroactively would create too great of a risk that many juveniles sentenced to mandatory life without parole prior to Miller were serving unconstitutionally disproportionate punishments, with Montgomery reiterating that the protection against disproportionate punishments is the central substantive guarantee of the Eighth Amendment.
Counsel, would you like to take a minute to wrap up?
Thank you, Chief Justice. Miller and Montgomery recognized that life without parole sentences for juveniles convicted of homicide are not necessarily unconstitutionally disproportionate, but they can be. To reduce the risk of a disproportionate sentence and give effect to Miller's substantive right, the Eighth Amendment requires sentencers to give individualized consideration to the mitigating circumstances of youth and all that accompanies it before imposing a life without parole sentence. The Eighth Amendment does not further impose specific procedures or require sentencers to follow a particular verbal formula. The sentencing court here had the benefit of Miller and took care to consider the implications of age, age-related characteristics, and the nature of the particularly brutal murder of Burdish Jones. On the whole, the sentencing court disagreed that youth and its attendant characteristics diminish the penological justifications for a life without parole punishment. The appellate court affirmed that sentence, and the court should be affirmed here.
Thank you, counsel. Mr. Liu?
Mr. Chief Justice, and may it please the court, this court in Montgomery answered the question presented here when it made clear that Miller does not require trial courts to make an affirmative finding of permanent incorrigibility. This court should reaffirm that conclusion for two reasons. First, whether a crime reflects transient immaturity isn't an inquiry separate from the inquiry Miller prescribes. Under Miller, a court must consider whether the distinctive attributes of youth have diminished the penological justifications for life without parole. When, as in this case, the court determines that they have not, that is a determination that the crime does not reflect transient immaturity, and no further finding is required. Second, even if transient immaturity required a separate finding, the court made such a finding here when it found petitioner's transient immaturity argument unpersuasive. For either of those reasons, the judgment below should be affirmed.
Counsel, I'd like to ask you the question that I understood Justice Kagan to be asking your friend from the state. I understand your submission to be that the requirement here is purely procedural. In other words, looking at page 15 of your brief, the sentencers have the ability to take into account youth and attendant characteristics, and if they do that, then that's enough. Is that a fair reading?
It's a fair reading of our brief that we think the inquiry Miller prescribes is enough to implement Miller's substantive rule. But I think this court need not go so far as to say part of the language in Montgomery announcing a substantive rule is right or wrong. We are willing to accept that language that draws a distinction between the two types of crimes we've been talking about. And our position is that even if you accept that language, the inquiry Miller prescribes is the inquiry to draw those distinctions.
Well, but how does that under Teague, how then is this rule properly considered retroactive?
Well, even if we take Montgomery at its word that the substantive rule in Miller is a distinction between crimes reflecting transient immaturity and crimes reflecting permanent incorrigibility, the next question is, well, what is a crime reflecting transient immaturity? And we think the court should just stick to what it said at the top of page 734 of Montgomery. It's there, I think it makes pretty clear that a crime reflects transient immaturity where the penological justifications for life without parole have collapsed in light of the distinctive attributes of youth. And once you have that understanding of what a crime reflecting transient immaturity is in mind, then it lines up exactly with the inquiry Miller prescribes. Because Miller on page 472 tells courts to ask, how do the distinctive attributes of youth diminish the penological justifications for a life without parole sentence? So a court
Thank
that
you, counsel. Justice Thomas?
I have no questions, Chief Justice.
Justice Breyer? Justice Breyer?
No, I have no questions. Thank you.
Justice Alito?
Suppose a judge says this after a sentencing hearing. I don't think this minor who committed this crime a month short of his 18th birthday is transiently immature. I think this person is highly intelligent and very mature. But I can't say that after 25 years in prison, he can't be rehabilitated. If he's released after 25 years, he will commit other crimes. What is the judge to do in that situation?
We think that is a legitimate thing for a judge to say. Well, what the judge is essentially saying is that the penological justifications for life without parole have not collapsed in light of the distinctive attributes of youth. The court is identifying an uncertainty about the future, but I think everyone agrees, including petitioner, that the burden can be placed on the defendant to show that a lower sentence is possible. So that uncertainty itself can't be dispositive in saying that the process is wrong.
Well, I don't quite understand the question. Suppose that the defense brings in a dozen highly qualified psychologists who say, we think that just about anybody who commits a crime short of 18 can, after a period of time in a good correctional facility, be rehabilitated so that the person will not create a risk for society after the person is released.
In that case, it's still within the judge's power to conclude that a life without parole sentence is appropriate if he thinks there are still penological justifications to support such a sentence. So the court could reason, for example, that while there is a possibility of some rehabilitation, it's not going to be enough to show true rehabilitation given how brutal and depraved the crime itself was.
I mean, Montgomery and Miller use a lot of language, possibly quite loosely. They use certain terms interchangeably: corruption, redemption, incorrigibility, and then contrasted that with transient immaturity. I'm not quite sure how they all fit together.
Well, I agree, Justice Alito, that those are not self-defining terms. I think it would help the analysis if the court were to make clear that the phrase crime reflecting transient immaturity means a crime where the penological justifications for a life without parole sentence have collapsed in light of the distinctive attributes of youth. And a crime reflecting permanent incorrigibility is a crime where those penological justifications have not collapsed. That would have the benefit of lining up the language in Montgomery with the inquiry Miller prescribes, but it would also have the benefit of allowing sentencing courts to conduct this inquiry the way they usually do, which is to consider the penological justification in light of a certain category of mitigating evidence and to ask whether that mitigating evidence is sufficiently compelling in a particular case.
Thank you, counsel. Justice Sotomayor?
Counsel, you and your co-counsel basically want to say that Miller and Montgomery mean only, does youth mitigate the horribleness of this crime. But that's not what Miller and Montgomery said. And in fact, what Miller and Montgomery said repeatedly was it would be the rarest juvenile that should receive life without parole. So how does your narrow proportionality approach, yours and your colleague, get to the nub of that?
Well, I think it just might be the case that when a sentencing court asks whether the penological justifications for life without parole have collapsed in light of the distinctive attributes of youth, that in most cases, the answer will be yes. And so I don't think there's
most cases, you're saying judges will find that these juveniles shouldn't be sentenced to life without parole, or are you saying that in most cases they should?
I'm saying that in most cases they shouldn't, because the penological justifications for such a sentence will be diminished, will collapse in light of the distinctive attributes of youth. It's not a question about the test. The test is, do those penological justifications collapse? It may be that the result in applying the test to cases out there in the world, that the test is satisfied, that is the
So, but how does the proportionality test that? That's what I'm trying to get to. It's very rarely applied. In Hamlin versus Michigan, we said possessing 672 grams of cocaine justified a life without parole.
Right. What the test I'm laying out about what a crime reflecting transient immaturity is a test that the sentencer applies in the first instance. It's not a narrow proportionality. It's not a gross proportionality. It just is, as a sentencer would ask in any case, whether certain mitigating evidence is sufficient to warrant a lower sentence. Now, the question that was before this court in the cases you mentioned was an appellate standard. And that appellate standard is more deferential to the sentencer. And so there is a level of grossness, a narrowness to the application of that test.
Thank you, counsel.
Justice Kagan?
Mr. Liu, I'd like to go back to a question that Justice Sotomayor asked Ms. Noble and get your view on it. Let's say that I'm a sentencer, and I go through a hearing, and at the end of the hearing, I say, I've considered this defendant's youth and the attendant characteristics of youth. I've done all that consideration. He's given me a lot of argument. I've listened to it all. To be honest, I don't think that his crime reflects irreparable corruption. You know, he is not one of the incorrigibles that Montgomery and Miller talk about. I think, in fact, that it's possible that he could be rehabilitated. But I also don't think that his youth is sufficiently mitigating for this horrible crime that he committed. So I'm sentencing him to life without parole. I think that that would be a good punishment and a proportionate punishment. Is that okay on your theory?
No, Justice Kagan, it's not okay. We think a resentencing there would be appropriate, but it's not because the court failed to make any specific finding. It's because the court in that hypothetical has made contradictory statements, essentially saying both that the crime reflects transient immaturity and that it does not. And I think it's a pretty well-accepted form of procedural error that when a court says contradictory things, we send it back for the court to clear.
I guess I don't understand that, Mr. Liu, because I took your argument to be one that said, these are just labels, the incorrigible label versus the transient immaturity label. What's necessary is that a judge take into account youth and consider it in I think Ms. Noble talked about an all things considered way, and this judge has done that. He's considered youth in an all things considered way. He's balanced it against a whole bunch of other factors, and he said that notwithstanding the possibility of rehabilitation, a LWOP sentence is appropriate. Is that not right?
It's because the labels do refer to specific concepts in our view. And so when a court uses the phrase crime reflecting transient immaturity, we're translating that into, I think, the penological justifications of youth have collapsed. If the court then says in the next breath, well, actually, I think the penological justifications have not collapsed, that's just saying two contradictory things. But what I'm not saying is that in every case, the court has to utter some magic words about transient immaturity. I'm saying when the court uses that phrase, but then says something that contradicts it, we should send it back to clear things up.
Thank you.
Justice Gorsuch?
No questions. Thank you.
Justice Kavanaugh?
Good morning, Mr. Liu. I want to follow up on my understanding of how this plays out in your view. If the process was good and perfect, my understanding is that you can't raise a different Eighth Amendment argument that the individual sentence was still disproportionate. The answer to that is the process is what leads to the proportionality, at least as an Eighth Amendment matter. And by analogy, in the death penalty context, the Gregg versus Georgia context, we have said proportionality is required, but it's achieved in two ways. One, you rule out the death penalty or life without parole for a certain class of offenses or offenders. And secondly, we require that the sentencer consider all the relevant mitigating and other relevant circumstances. That's the Lockett principle. And here, I just want to make sure your answer, if the process considers all the relevant circumstances, is there a separate argument as an Eighth Amendment matter that someone could still make, well, they applied all the relevant factors, but I still think it's disproportionate?
So we do, Justice Kavanaugh. I think the way to think about it is to compare this to the federal regime. As no doubt you're familiar, you can bring a procedural reasonableness claim under, say, Rita, but then a substantive reasonableness claim under Gall. And what we're saying here, this is a case about procedures. We're saying that there's nothing wrong with the procedures that were followed here. The court asked the right question and considered the right elements in answering that question. So there's no sort of procedural Eighth Amendment claim. We do think there's still room for a defendant to bring an as-applied Eighth Amendment claim. This is the sort of claim that the Chief Justice entertained in his concurrence in Graham versus Florida. I don't think Miller or Montgomery forecloses the availability of that type of claim.
Thank you.
Justice Barrett?
So, counsel, I guess I'm a little surprised to hear you say that you think that they can raise an as-applied substantive challenge to the proportionality because, I mean, I guess this is part of the confusion about whether Miller and Montgomery are substantive or procedural. But let me ask you this. If all the procedures, as Justice Kavanaugh said, were applied perfectly, what is the standard of review? Is it, well, the standard is grossly proportional because the defendant is not permanently incorrigible?
If there were a separate substantive Eighth Amendment claim brought, Justice Barrett, yes, the standard of review for an appellate court would be the narrow proportionality standard that the Chief Justice applied in his concurrence in Graham versus Florida.
So your objection here is really that it's making the state jump through too many hoops to put something actually formally on the record as a finding of fact.
That's correct.
Standard.
It would be as if in the federal system we had judges requiring trial courts to say, oh, I followed the parsimony principle. I really did consider whether this sentence was sufficient but not greater than necessary. Courts don't require that sort of uttering of magic words, and that's our objection to petitioner's submission here.
Okay, thank you.
Mr. Liu, a minute to wrap up.
Thank you, Mr. Chief Justice. I think this case turns on what the label crime reflecting transient immaturity means. We think it means a crime where the penological justifications of youth have collapsed in light of youth. And once we understand crime reflecting transient immaturity in that way, then there's no tension between Miller's substance and Miller's process, and there's no tension between page 734 of Montgomery, which draws the distinction, and page 735, which says no finding is required. Thank you.
Thank you, counsel. Mr. Shapiro, 3 minutes for rebuttal.
Thank you, Mr. Chief Justice. I want to be very clear that we are not asking for any sort of formal or affirmative or express or magic words type of finding requirement. All we are asking for is that the judge needs to understand that children who are capable of rehabilitation cannot be sentenced to life without parole, and to decide whether or not the defendant fits within the rule. As the Chief Justice noted, we are not asking for much. All that we are asking for is for the rule of Miller and Montgomery, which is a rule stated in Miller, reiterated in Montgomery 7 times as an integral part of its holding, that only permanently incorrigible juveniles can be sentenced to life without parole. And all we're saying is that means that there needs to be a determination. It can be an implicit one based on the usual presumption that the judge knows and applies the law correctly, a presumption that is overcome here, or it can be something more explicit. That is for the states to decide. My friend from Mississippi said that a weakness of our position is that we haven't laid out all of the details. But that's the point. The details are for the states. That is up to them in their discretion. But what there must absolutely be is a determination, implicit or explicit, that the defendant is incapable of rehabilitation before he or she is sentenced to life without parole. And I think what we've just heard from the other side is what a frontal attack on stare decisis and settled law is being made by my friends. My friend from Mississippi agreed that even a corrigible juvenile could be sentenced to life without parole. And my friend from the United States is dismissing the permanent incorrigibility rule as just a label and not really providing a direct answer to whether permanently incorrigible juveniles can be sentenced to life without parole. Montgomery provides that direct answer. Miller provides that direct answer in saying that trial courts need to distinguish between the two classes. And I think my friends from Mississippi, her comments illustrate what a free-for-all it is without a standard. It comes down to considering factors and deciding whether a lesser sentence is appropriate, all things considered. What we are saying is that there is a rule. This court has laid down that rule in Miller and Montgomery. It is part of the edifice of stare decisis and the stability interests that it protects. And this court does not lay down rules so that they cannot be applied. Mississippi courts need to decide whether Brett Jones is permanently incorrigible. Thank you.
Thank you, counsel. The case is submitted. We will hear argument next in case 1954-10, Borden versus United States. Mr. Shanmugam?
Thank you, Mr. Chief Justice, and may it please the Court. This case concerns the interpretation of the Armed Career Criminal Act's force clause. The most natural reading of that clause is that it reaches only uses of force that are intentionally or knowingly aimed at another person. The force clause therefore does not reach a person who uses force recklessly, because such a person is indifferent as to whether the force used falls on another person or on no one at all. Such an interpretation not only is compelled by the text of the force clause, but is supported by its broader context, namely to define the phrase violent felony and to identify those repeat offenders who are likely to point a gun at someone in the future and thus warrant a minimum of 15 years in prison. Until recently, our interpretation was the uniform interpretation of the Courts of Appeals, which relied on the text of the force clause and this Court's decision in Leocal construing it. That was seemingly settled law, and it gave rise to no apparent problems with the statute's reach. But in the wake of this Court's decision 4 years ago in Voisin, some Courts of Appeals, including the Court below, reversed course and adopted a contrary interpretation. Those courts were mistaken. In Voisin, this Court was interpreting different statutory language in a wholly different context, and it expressly reserved the question presented here. The government advocates an interpretation of the force clause that is grossly over-inclusive, sweeping in offenses such as reckless driving and thereby dramatically expanding the scope of the act. The text of the force clause does not support that interpretation, and it certainly does not unambiguously dictate it. At a minimum, given that every court of appeals had until recently rejected the government's interpretation, this court should apply the rule of lenity and hold that the force clause excludes reckless offenses. Whether as a matter of plain text or as a matter of lenity, the judgment of the Court of Appeals should be reversed. I welcome the Court's questions.
Thank you, Mr. Shanmugam. You rely heavily on Leocal and its statement, just to quote, that it's not natural to say that a person actively employs physical force against another person by accident. I'm not sure I understand that. If I'm at a sports event and jump up and wave my arms cheering and hit the person next to me, haven't I employed physical force against that person by accident?
Perhaps, Mr. Chief Justice, because in that hypothetical, the use of force is volitional. But we're really relying on a separate aspect of Leocal's reasoning. That is, that the against phrase is the critical and key phrase that limits the use of physical force and that defines the necessary degree of intent. And that's really how to reconcile Leocal with Voisin. In Voisin, the court was interpreting a statute that lacked that limiting language, and the court appropriately relied on the aspect of Leocal's reasoning to which you point in holding that the unlimited language reaches more broadly.
Well, what about something that's in recklessness? If I'm as part of a prank, I'm swinging a bat at someone, of course, meaning not to hit them, but, the bat slips and it does hit them. You'd certainly say that the conduct was reckless, and you'd say that it's directed against another person. So why isn't recklessness enough under that standard?
I would certainly say in that hypothetical, Mr. Chief Justice, that you have used physical force. But I would not say that you have used physical force against the person of another. And the government's alternative interpretation, I would respectfully submit, really reads the against phrase out of context. We're not disputing that.
Well, I don't understand that. If I'm swinging the bat at him, I'm certainly, and it ends up hitting him, I'm using physical force. I'm doing the swinging, and it's against him. I'm looking at him and swinging the bat at him.
Well, if you're looking at him and swinging the bat at him, that is much closer to intent. But I think what I would say, if you do it recklessly...
No, I don't mean to hit him. I have no intent to hit him. It's a joke, but unfortunately the bat slips.
Well, I would say that in that circumstance, you've used physical force, and the force has fallen on the other person. And again, if you accept the government's reasoning, I think it really would include not just reckless offenses, but also negligent offenses. And of course, that was the whole point of the relevant reasoning in Leocal. The court made quite clear that it was excluding not just accidental offenses, but also negligent offenses, and that it was relying on the against phrase. Now, if you don't accept...
Thank you, counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, I'd like you to go back to your reliance on the against phrase and your efforts to distance this case from Voisin. I thought that in Voisin that the statute there covered the use of force by a person with whom the victim shares a child in common, by a person who is cohabiting with or has cohabited with the victim as a spouse. So it seems that even though it doesn't use the term against, it does strongly suggest that the absence of that word makes absolutely no difference to the analysis.
So I don't think that that's true, Justice Thomas, for two reasons. First, in the opinion in Voisin itself, the court at page 2279 of the Supreme Court Reporter quoted the exact language I was relying on with the Chief Justice. That is to say, it quoted the language from Leocal relying on the phrase against the person or property of another. So I think the court was very sensitive to that. But second, to go to the reference in section 922G9 to a victim, I don't think that the government can get very much purchase out of that, and indeed the government really doesn't try to rely on that. But I do think that some lower courts have been somewhat misled by it. And let me explain, if I can, why I think that reference isn't tantamount to the inclusion of a phrase like against the person of another. Section 922G9 does not require the use of force against the victim. Instead, it only refers to the victim in defining the offender. And it was really for that reason that this court, in a case called United States versus Hayes, in an opinion written by Justice Ginsburg, concluded that the relationship with the victim is not even an element under Section 922G9. And so, again, some lower courts have, I think, looked to that reference, but I think that those lower courts have not focused on the fact that this court in Hayes really rejected the notion that this was equivalent to a phrase requiring the use of force against a victim.
One final question. If Johnson, if we had not held that the residual clause was unconstitutionally vague, would this be the type of case that would have fallen under, or statute that would have fallen under the residual clause rather than this clause?
Well, perhaps, but with one caveat, Justice Thomas, and I'll be brief. In Begay and then in Sykes, this court had a very vigorous back and forth on whether the residual clause extended to reckless offenses, and I think by the end of Sykes, the court had effectively restricted the residual clause to intentional offenses, and of course it would be highly anomalous to take a broader view of the force clause here.
Thank you.
Justice Breyer?
Thank you. My one question for you is, suppose we take what I think is the best definition of recklessness, that a person is reckless when he consciously disregards a substantial and unjustifiable risk that the bad result will follow. So to take the Chief Justice's example, I have my baseball bat I'm swinging around. I know I am the worst baseball player in history. I know that this baseball bat is likely to slip out of my hands and bonk somebody on the head. There is a person standing in front of me. I think, oh God, that person may be hit. I don't want him to, but he might be because I'm so bad. And then I swing it, and he's hit. All right, what's the difference really between that and my committing a crime knowing that that result is likely to follow, or desiring it intentionally, purposely, that it's likely to follow?
Sure. So, Justice Breyer, I would make 2 points in response to that. The first is that this is a familiar and meaningful distinction in the law. It's a distinction that the Model Penal Code itself describes as important, and that is simply the distinction between an action that is intended to cause harm and an action that is not intended to cause harm, but merely involves a substantial risk of it. And that is the distinction that we think that the language of the force clause captures. But I would make one additional point that I have not made to date, and that is that even if you think that the against phrase doesn't do all of the work, I would submit that this Court's decisions, and particularly its decision in Begay, do the remainder of the work because they make clear that the relevant language must be understood in its statutory context, which is to provide a definition of the phrase violent felony. And where someone acts recklessly, even though the law obviously attributes to that person a substantial degree of moral culpability, that action simply doesn't fall within the ordinary meaning of violent felony. And the second point I would make, Justice Breyer, is that whatever you might think about sort of the fine gradations in particular hypotheticals, I would respectfully submit that it would be a lot harder to draw the line between recklessness and criminal negligence, because negligence itself in the Model Penal Code is defined as being a situation in which an actor should be aware of, once again, a substantial and unjustifiable risk. As the government recognizes in footnote 5 of its brief, states often define criminal negligence in recklessness terms, and as Professor Littman's amicus brief recognizes, the line between those two categories is fuzzy.
Justice Alito?
Suppose a particular defendant has 3 prior convictions for second-degree murder in a jurisdiction like federal court, I believe, where the minimum mens rea required for that is a form of recklessness. You would say that that person does not qualify under the Armed Career Criminal Act. Is that correct?
Not necessarily, Justice Alito, and that is because when you're talking about second-degree murder, whether under federal law or under state law, typically the state of mind that's required is the state of mind that we learned about in law school, a so-called depraved heart or extreme recklessness. Now, I think probably the better view is that extreme recklessness still doesn't qualify under our textual interpretation, but I would acknowledge that there are good reasons potentially to treat extreme recklessness differently from ordinary recklessness. The Model Penal Code itself appears to equate that state of mind with intent or knowledge. It equates depraved heart murder with...
Well, a typical definition for depraved heart murder simply requires a very high degree of risk and an extreme disregard of life. And you just acknowledge it would be pretty hard for us to say that's okay, but ordinary recklessness is not.
Yeah, I'm happy to acknowledge that, Justice Alito. And again, it's because, as you say, we're talking about extreme indifference to human life, such as shooting into a crowd. And I think courts have pretty consistently treated that as tantamount to acting intentionally or knowingly.
All right, now, suppose a person shooting into a crowd, suppose a person looks at a crowd of people, or just looks at a single person, and this person's got has got a hairdo that sticks up quite a bit, and on top of the hairdo there is a hat. And the person says, oh, I don't know how great a shot I am, but I'm going to try to pick off that hat without touching a hair on the person's head. That would it be a stretch to say that that is the use of force against the person of the target?
I think it would be a stretch to say that, though. As you say, if the hat is on the person, it sort of feels as if the hat is part of the person. But, again, I'm willing to recognize that there may be close cases. There are close cases when prosecutors make charging decisions as to all of these states of mind. I think our principal submission, Justice Alito, is simply the point that you made on the Third Circuit in the Oyabanji case, and that is that a reckless offense, an offense involving ordinary recklessness, although involving a substantial degree of moral culpability, does not fall within the ordinary meaning of violent crime, much less the ordinary meaning of violent felony.
Well, I was on a court of appeals at the time, and I acknowledged that I had to follow Supreme Court opinions, and the latest opinion there was Leocal. Let me see if I can sneak in one more question. Suppose a statute referred to the reckless use of force against the person of another. Would that be an incoherent statement? Would that be gibberish?
I think in that hypothetical, the explicit use of recklessness might override what would otherwise be the plain meaning of the phrase use of force against the person of another. But I would respectfully submit that that's just not how a person would ordinarily speak. And if Congress was trying to convey that meaning, it would have said something like the use of physical force that recklessly causes injury to another person.
All right, thank you. Thank you. My time is up.
Justice Sotomayor?
Counsel, I accept that there are reckless uses of force that come close to intentional. The Chief, Justice Alito, have given you examples of that. But as I look at the charging statutes that encompass recklessness, many of them, including in Tennessee, where this crime was committed, involve conduct that's hard to think of as reckless and more as negligent. For example, the individual who was charged with recklessly causing injury, who was blinded by the sun. And there are other examples of that. Isn't that the whole point of this exercise? That because recklessness is not necessarily an act directed against another person, that's why it cannot qualify as a crime of violence?
Yes, that's correct, Justice Sotomayor. And I think it's important for the court to keep in mind here that we're not talking about individual cases. We're talking about state statutes. And state statutes ordinarily draw a meaningful distinction between intent and recklessness. Indeed, the Tennessee statute at issue here separately defines intentional aggravated assault and reckless aggravated assault. Not surprisingly, Tennessee imposes stricter penalties on the former. And so, to the extent, again, that we're talking about extreme recklessness, which tends to come up primarily in the context of murder, I think it would be entirely appropriate for the court either to reserve that question or even to indicate that extreme recklessness is tantamount to intent or knowledge. The second point I would make is, again, looking at state statutes, I really do think that once you start drawing the line between recklessness and negligence, that these are really fine distinctions that involve the degree of risk, the extent of awareness of risk. And, of course, our fundamental submission to the court today is that if you agree, as I think one respectfully must, that this court in Leocal indicated that negligent offenses are excluded, there's simply no way from this statutory language to treat reckless and negligent offenses differently.
Thank you, counsel.
Justice Kagan?
Mr. Shanmugam, I'm again interested in your textual argument about the against the person of another phrase. And I guess what some of these hypotheticals that have been thrown your way make me think is that phrase really just doesn't have anything to do with mens rea. What it has something to do with is the actus reus. It has something to do with defining what the act is, that it's an act directed at the person of another, but is sort of indifferent to what the person's intent is. So I was wondering whether you could respond to that.
I would make 2 points in response to that, Justice Kagan. The first, picking up on something I said earlier, is that in Leocal itself, the court made clear that it viewed that language as defining the degree of intent. And I think that it's easiest to sort of understand that when you think about against, not in isolation as the government would have you do, but again, when you think about using force against the person of another. Again, if I throw a plate at a wall to try to hit a spider and the plate hits my wife instead, I think an ordinary English speaker would say that you're using physical force against the spider and not against my wife.
Let me give you a couple of different hypotheticals, and this is a paired set. So the first one should be easy. The first one, I'm a bank robber, and I'm running out of the bank, and I really have to get out in a hurry, and my car is in a parking lot, and I see that there's a man right behind my car, and I know that when I get out, I'm going to run him over. Is that the use of physical force against the person of another?
Yes, it is, because you're certain or practically certain that you're going to run over the man.
Absolutely. So now exact same facts, except the person is 8 feet away from the car. So there's a very substantial risk that when I back up, I'm going to hit him. But it's possible that if the guy is looking just my way and if he's fast enough, he's going to escape. Is that the use of physical force against a person of another?
I don't think so, and I think that it's true. I think that's true for the reason that we've been discussing. Again, I think that when you're using physical force against a person, that suggests that the force is being directed at that person.
But I know that this guy is standing 6 feet in back of me, and he's going to have to be really lucky to get out of the way of my car. He's going to be, very fleet of foot, and otherwise I'm going to hit him. I guess I just see, okay, there's a difference in risk level, but I don't see why we should say that one is the use of physical force against another and the other is not.
I think because you, in that hypothetical, are conscious of the risk, and the risk may be very high, but that is a meaningful distinction at law. And to respond just very briefly to your point about the actus reus, Justice Kagan, I think that if that were all that phrase were doing, it's really impossible to make any sense out of Leocal, because there the phrase was against the person or property of another, and if you were simply defining the actus reus, that language would have been superfluous.
Thank you, Mr. Shanmugam.
Justice Gorsuch?
Good morning, counsel. I appreciate that you want us to draw a firm and clear line between recklessness and negligence, as the model penal code does. But I've been kind of curious by some of your responses which blur the line between recklessness and other mens rea higher up, knowledge and intent, which the model penal code also treats as distinct, and importantly so. And I guess I'm curious where you think the statute draws the line. Would a knowledge crime trigger the ACCA under your view? It seems like in the reply brief you concede that almost, but I'm not clear why.
Yes, I believe that it would. And so let me just walk very briefly, if I may, Justice Gorsuch, through these different states of mind. Knowledge doesn't, frankly, tend to come up as often with these sorts of offenses, but the law generally treats intent and knowledge as effectively equivalent.
Well, no, that's where you're wrong. It certainly does at tort, but the model penal code draws a firm distinction between them. And it's true that sometimes a jury can infer intent from knowledge, because very few defendants will admit they secretly harbored a nefarious intention. And it's also true that in tort and other areas we sometimes collapse the two. But the model penal code treats them as distinct. So let's assume I'm right about that for just argument's sake. Then what?
Justice Gorsuch, let me make one quick point in response to that,
please, with my limited time,
yes,
just answer
when you're talking about knowledge of the result as opposed to knowledge of some specific fact, I think the law does treat the two as effectively equivalent. When you act with knowledge that your conduct will cause a particular result.
I really don't want to get involved in that argument with you. Okay, assume that intent and knowledge are distinct mental elements, and it can be. It may be the statute depends on what the object of the mens rea may be different. Okay, whether the consequences you have to have a mens rea attached to or not. Forget about that. Okay, forget about all of that. Why wouldn't we, if we're taking the statute seriously and looking at the rule of lenity, start with the assumption that until Congress tells us otherwise, this has to be an intent statute?
I think with regard to offenses such as assault, murder, rape, and the like, the offenses that Congress seemingly intended to cover, so what you're really talking about is intent, with the exceptions that we've been talking about today. But I would say that the distinction between intent and knowledge on the one hand and recklessness is a meaningful one for the reason I suggested earlier. It's the distinction between an action that is intended to cause harm or that is known to cause harm.
Thank you.
Justice Kavanaugh?
Good morning, Mr. Shanmugam. If the statute said use of physical force, period, would that cover reckless offenses?
That would be textually equivalent to the statute in Voisin, but I would have my fallback argument concerning the context.
Okay, but if we followed Voisin, then yes. So it's because it says if it said use of force, it covers reckless offenses. If it says use of force against another, it does not cover reckless offenses. And I guess I'm just thinking that's a very strange line to draw. Judge Sutton in Verweebe, and he's a very wise judge, as you know, said sometimes the simplest explanation is the best explanation. And it seems like if you're trying to make sense of Leocal and Voisin together, the simplest and I think potentially the best explanation, I want to get your reaction, is negligent conduct is not use of force, and reckless conduct is use of force for purposes of these statute, because I think to pick up on what Justice Thomas said, it would be a bit wild to say reckless crimes are covered by use of force, quote, statutes, but not by use of force against another, end quote, statutes. So can you respond to that?
Justice Kavanaugh, here's why I think the two statutes have to be interpreted differently. It's because of negligent offenses. I think that under the reasoning of Voisin, if you were dealing with that statute, section 922G9, which again came up in a very different context, that a negligent offense would qualify as the use of force because the use of force in a case involving negligence is volitional. By contrast, it is clear that under the different language at issue here, in the wake of this court's decision in Leocal, negligent offenses would be excluded. And I think with respect, I would rely on the reasoning of not Judge Sutton, but Judge Kethledge, relying on this distinction in the text and relying on the very important distinction of the context.
Well, on the textual point, I think you're making a point, I think, that ordinary usage of against the person of another is itself what excludes recklessness. But then if you look at the Voisin opinion, and I don't mean this as a gotcha point at all, but just kind of an example of ordinary usage, it describes the offense there, even though the statute didn't say against another, on page 1, as any misdemeanor committed against a domestic relation. On page 4, recklessly assaulting a domestic relation. On page 7, the harm such conduct causes the result of deliberate decision to endanger another. Page 8, who assaults another. Page 9, referring to the main statute, to recklessly injure another. And page 12, federal law applies to those with prior conviction for the use of physical force against a domestic relation. The point being, in explaining the ordinary use of the phrase use of force, it was describing it indistinguishable from use of force against another. Can you respond to that?
Yes, Justice Kavanaugh. Very briefly, I think that is simply reflective of the fact that the force falls on the victim when you're dealing with a reckless offense like a negligent offense. And again, the court went on for pages about the distinct context of Section 922G9, which was to serve the public safety purpose of taking guns out of the hands of anyone who is engaged in domestic abuse, even misdemeanors.
Thank you very much.
Justice Barrett?
Good morning, Mr. Shanmugam. A few minutes ago, you said that Congress, you described the heartland of crimes of violence as murder, rape, assault. I have a question about assault. Many statutes include recklessness in the definition of assault. So wouldn't the categorical approach mean that if recklessness isn't included, assault's out?
Good morning, Justice Barrett. I would say two things about assault. First, I think it's important to keep in mind that we're talking here about felony assault and not about misdemeanor assault. And in Voisin, to the extent that the court talked about misdemeanor assault, that was simply because that statute covered felonies and misdemeanors. With regard to felony assault itself, the government correctly notes that in a number of states, it's around half of them, there are reckless felony assault offenses. But in the majority of those states, there are discrete assault offenses that could be committed intentionally or knowingly. Indeed, that's true in Tennessee, as the law at issue here reflects. And the fundamental problem with the government's effort to turn this into a state counting exercise like the one at issue in Voisin is that here there's no evidence that Congress sought to sweep in every variant of offenses such as robbery and felony assault. as opposed to the most serious versions of those offenses, those that are committed intentionally or knowingly. And in Voisin, the court attached significant weight to the fact that if the defendant's interpretation were adopted, Section 922G9 would be affirmatively inoperative in a majority of the states. That's clearly not true here. And indeed, for more than a decade, we lived with our interpretation without any evident difficulties of under-inclusiveness or difficulties of administration. It's
Mr.
only
Shanahan,
really...
let me just interrupt so I don't run out of time. I have another question. So the word against, let me just read you this definition. It can mean into contact or collision with, toward, upon. In Justice Kagan's hypothetical, where the bank robber is pulling out and she sees in the rearview mirror that someone is standing 8 feet behind the car, why doesn't that definition fairly encompass a use of force that is toward, in collision with someone, or conscious disregard of the risk of someone? It doesn't seem to me a stretch of the English language to use it that way.
We don't dispute, Justice Barrett, that in isolation, against could define the object of force. But here, the word against is being used with use of force, and that makes all the difference. The government, in its brief, talks about the application of force. It certainly would be true that if you hit a baseball against a windshield, that the ball has hit the windshield. But you wouldn't say that you've used force against the windshield if your intent is not for the ball to land on the windshield.
Thank you.
Mr. Shanmugam, a minute to wrap up.
Thank you, Mr. Chief Justice. As the government prepares to present its argument, I would respectfully submit that there are really two fundamental problems with its position. The first is the one that we've been discussing, which is that the government's position really fails to come to grips with how this court construed the materially identical statutory language in Leocal. And again, I think there's simply no way that that language can be construed to encompass reckless offenses but not negligent ones, never mind unambiguously as the rule of lenity would require. I think the second problem is that the government's interpretation would sweep in a host of unintentional and nonviolent offenses, particularly reckless driving offenses, which the United States Code itself breaks out from crimes of violence. And a mom who fails to buckle in her child and then gets into an accident is not the sort of offender who is likely to point a gun at someone in the future. Again, our interpretation was the interpretation of the lower courts with no evident difficulties for more than a decade, and the Court of Appeals here should have followed suit. Thank you.
Thank you, counsel. Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the Court. The reasoning of this Court's decision in Voisin resolves this case. As Justice Kavanaugh pointed out, Voisin described recklessly causing injury to a domestic relation as the, quote, use of physical force against a domestic relation, unquote. It necessarily follows that recklessly causing injury to the person of another is the use of physical force against the person of another. It makes no difference that in Voisin, the phrase against a domestic relation was the court's own descriptive language, while here the phrase against the person of another is Congress's descriptive language. No matter who says it, as Justice Kagan pointed out, it's a natural way to refer to the object of the actus reus of the crime. Petitioner nevertheless insists that the word against indirectly cuts out reckless offenses on the theory that it necessarily imposes a targeting requirement. But if that targeting theory were correct, then as Justice Gorsuch pointed out, even offenses with a mens rea of knowledge, and certainly offenses with a mens rea of extreme recklessness, would be excluded, a result the petitioner himself disavows. And this court's decision in Voisin, background principles of criminal law as to default states of liability, and common sense all group knowingly causing injury with recklessly causing injury, which by definition involves the knowing disregard of a substantial and unjustifiable risk that an injury will occur. That very line is reflected in the felony assault offenses of approximately 30 states, the robbery offenses of approximately 11 states, and the murder offenses of approximately 36 states in 1986. The petitioner's reading would apparently have excluded at least a form of and a very core form of.
Counsel, it it seems to me that you're putting an awful lot of weight on Voisin. The against domestic relation there was used in a sort of colloquial manner. I think certainly not as a technical statutory interpretation.
Well, Your Honor, I heard my friend on the other side to say that he thinks when you add against, the meaning changes because it's plain that you couldn't possibly use this language to mean what the majority of courts of appeals have interpreted it to mean since Voisin. And I think this court's use of the phrase in its own language in the opinion in Voisin on page 2282 illustrates that that plain meaning argument that he's making can't possibly be right. It shows the language can be used in this way, and Congress did use the language that way.
The recklessness does cover a fairly broad range. You know, it does cover swinging the baseball bat that slips, but as I think your friend on the other side just noted, it can also cover things like, you know, failing to buckle in the child in the car seat, or texting while driving, and I don't think in any of those situations you would say that that's using force against those individuals.
Well, a couple of points, Your Honor. First of all, as to the driving examples, we're not really talking about reckless driving in the abstract. We're talking about cases in which someone's been charged with felony assault based on his or her conduct with a car. And I think
don't people get, maybe I'm wrong, but don't people get charged with that in some instances when they're doing something like, you know, texting while driving or that sort of thing?
Your Honor, I'm not going to say it's never happened, but I think we describe at pages 41 to 42 of our brief, pages 38 to 40 of our brief, we describe the examples of reckless assault based on conduct with a car that they've been able to come up with, and they're all much more extreme than that. These are people who are vastly exceeding the speed limit through neighborhoods, running various stop signals, then they T-bone someone, they head-on collide with someone, or they kill someone.
Well, and you're comfortable describing that activity as a crime of violence? The activity I just described, yes, Your Honor. And as to the label, I think, well, the courts looked at that as to the degree of force. It doesn't make much sense to look at it as to the mens rea. There's reckless conduct like shooting into a crowded house that I think everyone would describe as violent. And there's intentional conduct like an Agatha Christie-style sedate murder by poisoning someone's tea that I don't think anyone would really describe as violent, but that everyone agrees is covered. Thank you, Counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, just briefly, if you could, there seems to be a bit of tension between Voisin and Leocal. Could you just comment on that, and then also spend a little bit of time explaining why Leocal doesn't imperil your case?
Sure, Your Honor. I think that Voisin itself resolves any tension between Voisin and Leocal because Voisin explains that the reasoning of Leocal is simply a distinction between accidental offenses, which would include negligent crimes, and non-accidental offenses, which Voisin makes clear include reckless crimes. Now, it doesn't focus at all on the linguistic distinctions between the two statutes, and I'll get to that in 1 second, why those shouldn't matter. But the reason we know that the reason Voisin doesn't focus on that is because Voisin accepted that even under the statute at issue in that case, that force against a victim was required. And that can be shown from the court's own example of someone who recklessly throws a plate at a wall. It wasn't enough that the person knew or intended to use force against the plate. The critical question for whether the main assault statute was covered was whether the person was reckless that a shard from that plate might hit the domestic victim. And the reason that the additional language doesn't matter is because it has independent weight. My friend on the other side suggests that it has no meaning if it doesn't impose the targeting restriction that he would impose, but it actually does two things. First of all, it makes sure that the injury is to a person and not to property. But even as to similarly worded statutes that include both persons and property, the requirement that it be against another is a significant limitation. It's why arson does not qualify as a crime of violence under 18 U.S.C. 16A or 924C3A, because you can commit it by burning down your own house for the insurance money. So we can't include that crime under phrases like this.
If the residual clause were still in use and had not been done away with as unconstitutionally vague, wouldn't that be a more natural place for this particular case or this charge?
Well, Your Honor, there's substantial overlap between the residual clause and the elements clause, but they each have their distinct role. And to the extent that my friend on the other side is suggesting that the residual clause might have excluded this or might not have, I think the elements clause here focuses on crimes that actually involve the use of force, where someone is, in this case, actually injured. And in those circumstances, I think reckless crimes were clearly crimes Congress would want to cover, because we know that they wanted the elements clause to reach things like robbery, felony assault, and certainly second-degree murder.
Thank you.
Justice Breyer? Going back to the statute itself, what it does is it takes, say, possession of a firearm or ammunition, which is illegal, and it changes the sentence from no minimum, up to 10 years, to a 15-year minimum sentence, up to life. And that happens where you have 3 prior crimes that fit the definition. That's a pretty serious consequence. So this court, I think, has struggled to try to make sure the really bad things are in those 3 priors and not things that are not quite so bad. So that's why I find Leocal and Begay pretty much on point. Now, Begay, we had drunk driving. And quite a few states make drunk driving, they put in that recklessness. All right, we had it, and we said in the residual clause, you have to have, the residual clause is closer to what you want because it talks about a serious potential risk of physical injury. And we said there has to be conduct in those 3 priors that is violent, aggressive, and purposeful. Now, where you have a residual clause and you have words that are much closer to here, and we're trying to get out drunk driving because it just isn't the right category given the statute, why isn't this case a fortiori?
Well, Your Honor, in Begay, this court was considering a drunk driving statute that didn't have a mens rea requirement at all, and it didn't reach the question whether reckless felony assaults, which is what these cases that are we're talking about here, would be covered by the residual clause. The second thing that I would say is the court never resolved whether the residual clause covers reckless offenses, and so if it really mattered whether it did, I don't think that necessarily cuts in petitioner's favor. But the third thing I would say is even if you thought it didn't, I think that actually makes our case stronger, because if we can't get in things like reckless murder under the residual clause, then Congress surely wanted to include them under the elements clause. As I was saying to Justice Thomas, the elements clause is more restricted in that it is directed at occasions where force is actually used, whereas the residual clause, and ultimately to its doom, was focused on possibilities and whether or not something might ultimately result in the use of force.
One last thing.
I'm sorry, Justice Breyer.
Is there a difference between the words you have just used, which were reckless murder with a car, and the words I'm going to call drunk driving? Is that a big difference? And as after all, it was because we thought there wasn't that that word purposeful appears in Begay. So that was the basic reason. So what do you think about that?
Well, again, Your Honor, the drunk driving statute in Begay didn't have a mens rea requirement at all, and so the court didn't.
Well, the word purposeful did not purport to be an interpretation just about driving. It purported to be an interpretation of the residual clause, which is relevant here insofar as for the reasons I said.
Yes, Your Honor, but
Purposeful was across the board.
Well, Your Honor, another thing the court was trying to do in that case, and it ultimately abandoned this project, was to grope for a standard that applies to the residual clause in particular. And what it did in that case was it looked to the enumerated offenses clause that directly precedes the residual clause, and it tried to figure out some way to group those four particular offenses together. We don't have that issue.
Justice Alito?
Well, it's always a pleasure to have another case involving the Armed Career Criminal Act. It is a real favorite. Do you think that Leocal allows us to say that the phrase "against the person of another" does not speak at all to the question of mens rea?
Your Honor, I think it may have some kind of contextual influence on mens rea, but no more so than it had in Forcine, because in Forcine, as I was saying earlier in response to Justice Thomas, you had a similar context where you needed somebody who was injured. And I want to be quite clear that we really are only talking today about crimes that require the actual causation of injury. Somebody actually was hurt, and then the defendant was reckless as to whether someone would get hurt. Because those are the set of crimes that the court has in front of it today, and only in crimes that involve the actual causation of injury would we even be able to prove that a force capable of causing pain or injury in fact took place.
Now you point out that if we adopt petitioner's interpretation, crimes like second-degree murder and a lot of assault offenses will not qualify as ACCA predicates, and the petitioner responds that if we adopt your interpretation, drunk driving offenses and other less serious offenses involving reckless conduct will qualify. So which of these two parades of horribles is more horrible?
If horribleness is a good thing, then I think our parade of horribles is more horrible, and let me give you two concrete reasons why. First of all, we've done a survey, and these numbers are a bit approximate, but we're only aware of maybe a maximum of approximately 10 or 12 states that have separate driving-specific offenses that we think might even qualify as ACCA predicates. And most of those states label those crimes vehicular assault or vehicular homicide. And so they treat them much more seriously than they do kind of regular drunk driving. And I guess the second and related point I would make about that is, to the extent that my friend's position depends on these kind of isolated examples of seemingly innocuous conduct that might in theory be covered by one of these statutes. This court in Quarles may recall that one of the major arguments made there was that there were seemingly innocuous ways to commit certain forms of burglary, and the court looked at what Congress was trying to do as a categorical matter, and just because that can happen once doesn't mean it's going to happen 3 times to someone such that they're classified under the ACCA. And if you look at the set of offenses that they would cut out, which are felony assault by injury, second-degree murder, and common law robbery, which the court described in Stokeling as the paradigmatic elements clause offense, I think it's quite clear that our reading is much better than theirs.
All right, thank you, counsel.
Justice Sotomayor?
Counsel, in terms of the parade of horribles, I do think it's important to remember that judges always have the ability to decide somebody or to hold that reckless conduct doesn't qualify you for an ACCA enhancement, but that the crime you committed, all the horribles that you describe, do command a greater sentence. So it's not as if these people are going to get away scot-free. I also point to something that the government said in its response brief in Vosine, that responsive brief made an opposite point than the one you advanced today. I'm quoting for your Vosine brief, quote, while both provisions contain the phrase use of physical force, the domestic violence provision and ACCA, the misdemeanor crime of violence definition omits the remainder of the Leo-Cal's provision section 16 definition, which qualifies that the force is against the person or property of another. You said the against phrase was crucial to Leo-Cal's holding, which required a higher mens rea. And yet today you're telling us that that against force directed against the person has no meaning. That the only meaning is, was your conduct reckless and that it happened to cause physical injury? Were you wrong then and right now?
Your Honor, I don't think that we placed that amount of weight on the phrase in that case. I think we noted that Leo-Cal had relied on it, but I don't think we were placing just positive weight on it. But even if you see some tension between our position in Vosine and our position here today, there's been a significant intervening event, which is the decision in Vosine, which I think clears up the misimpression that the courts of appeals had been laboring under, as Justice Alito referred to in my friend's part of the argument, that Leo-Cal actually controlled the question of reckless conduct, and Vosine did so in a way that didn't rely on those linguistic distinctions. Vosine makes clear that what Leo-Cal is really about is the difference between accidental and reckless conduct, and that's the exact line that the criminal law draws. And there's a really good reason why the criminal law draws that line. It's because the distinction between knowledge and recklessness is simply one of degree, and the distinction between recklessness and negligence...
Since my time is limited, in Leo-Cal, we said that a DWI cannot be a crime of violence because it does not require the use of force against the person of another. And it happened to be negligence, but its entire focus was the force directed at another person? It seems to me that since Tennessee and many other states are putting drunken driving in their assault statutes like this one, that what we're doing is sub silentio overruling Leo-Cal. Maybe not sub silentio, but that's what our intent is, and that's what you're asking us to do.
No, Your Honor. Leo-Cal expressly reserved the question of reckless offenses, so it didn't consider this here. It was like, as in Begay, considering an offense that didn't have a mental state at all. So I don't think that what we're asking you to do today would sub silentio overrule Leo-Cal. We don't think that the mere crime of drunk driving as such is included within the ACCA. It would not be an ACCA predicate.
Thank you, counsel. Justice Kagan?
Mr. Fagan, as you know, Voisin expressly reserves this question, just as Leo-Cal expressly reserved the recklessness question. And in that footnote where it does reserve it, it says the context and purposes of the statutes may be sufficiently different to require a different reading. And this, I suppose, goes back to Justice Breyer's questions, because I think the argument might go, or at least part of the argument might go, that in ACCA, one is defining what it means to be a violent felon for purposes of imposing an extremely significant punishment, whereas in this statute, one is talking about misdemeanors and applying only a prophylactic rule about gun possession. And further, I mean, Voisin spends as much time talking about the effects of coming out the other way than it does about the text. In other words, it basically says, if we don't hold the way we are holding today, this entire federal scheme will be rendered inoperative. And that seems very different, no matter if you can come up with, 13 robbery statutes or something like that. That seems an extremely different consequence of a ruling. So I guess I would ask you to respond to that set of things that might serve to distinguish this case from Voisin.
Sure, Your Honor. Let me say three things about that. First of all, I think the different contexts actually cut in our direction because, first of all, they removed the Second Amendment concerns that Justice Thomas voiced in his dissenting opinion in Voisin. And second, the second point I would make is that here you require 3 serious felony offenses, whereas there a single misdemeanor crime would have sufficed. And as I was suggesting earlier, we're talking about cases where people have been charged with felony assault or murder or robbery or a serious offense like that, and we're not simply talking about cases where one crime makes all the difference. And the third thing I would say is that if you hold for petitioner in this case, I think you're going to reintroduce the exact same anomaly that you avoided in Voisin. As we explain on page 36 of our brief, the similarly worded elements clause in 18 U.S.C. 16, which defines crime of violence, is incorporated into the Immigration and Nationality Act's definition of crime of domestic violence. And if these reckless crimes are excluded, then the 35 state misdemeanor assault offenses that the court focused on in Voisin wouldn't qualify under the Immigration and Nationality Act either. And I think it would be quite surprising to Congress to find that a fairly subtle change of wording, one statute requiring that the crime be committed by domestic relation and the other statute requiring that it be against the person of another, make that big a difference as to whether the scheme works as it was intended to.
Thank you, Mr. Fagan.
Justice Gorsuch?
Good morning, Mr. Fagan. I guess one other possible distinction textually between this and Voisin, of course, is that we don't have the phrase against the person or property of another. And I know in that case, and we do here, and in Leocal, I guess I'm still stuck. You don't seem to want us to read very much into that phrase, but Leocal says, whether or not the word use alone supplies a mens rea element, the party's primary focus on that word is too narrow. And then it goes on to say the key phrase, use of physical force against the person or property of another, most naturally suggests a higher degree of intent than negligent or merely accidental, suggesting that phrase has some work to do in mens rea. And I guess I'm still struggling with how, if we're to take our precedent seriously, we ignore that instruction, which isn't present in Voisin, relevant in Voisin.
Sure, Your Honor. We're not asking you to ignore it. I think you could say the same thing here, that it's, of course, informed by the context of a requirement to use force against the person of another. But
that answer that it just relates to the object of the force runs directly counter to Leocal's express instruction that it has something to say about mens rea. And it also renders, as your friend pointed out, that phrase, person of another or property of another, superfluous in Leocal itself. What do we do about that?
Well, Your Honor, let me say, I appreciate the chance to clear this up. Let me clarify that I think grammatically under the last antecedent rule, the phrase just modifies physical force, so it refers to the object of physical force.
Yeah, but that doesn't work because of Leocal's express instruction that it has something to say about mens rea. So
right.
Assume that doesn't work as a matter of precedent if we're to take our precedent seriously.
So I think what Leocal recognizes is that when you're interpreting the clause as a whole, you take the words in context, and you take the word used in the context of that language. But the critical point I would make here is that I think Voisin is interpreting it in the same type of context. Because
that phrase isn't in Voisin is your problem. Let me ask you another question if we're not going to get forward progress there. What do we do about the rule of lenity? And this statute is supposed to provide notice not to 9 judges on the Supreme Court who are struggling with it, but to ordinary Americans. And if we can't make heads or tails of it, and every circuit to have addressed it up until recently came out against you, why shouldn't we, if Congress wishes to legislate here further, and of course it may, but why shouldn't we here say the tie goes to the defendant, the presumptively free defendant?
Well, Your Honor, the rule of lenity, of course, requires grievous ambiguity, and Voisin found the result there to be plain, notwithstanding that the circuit consensus was against it. And I think it would be quite anomalous to say that here, as the rule of lenity, application of the rule of lenity would require, that the court is left to do nothing more than guess as to what Congress intended. I think it's particularly clear after Voisin what Congress intended to do here.
Thank you, counsel.
Justice Kavanaugh?
Good afternoon, Mr. Fagan. I want to pick up on Justice Gorsuch's point about precedent, because we have 2 precedents we have to make sense of, Leocal and Voisin. And in your brief, I thought the answer that you were giving about the distinction of Leocal, and this is page 13 of your brief, the court in Voisin accordingly made clear that the critical distinction recognized in Leocal itself is between accidents and recklessness, not recklessness and knowledge or intention. In other words, that Leocal stands for the idea that negligence doesn't come within this kind of language. Is that right?
That's right, Your Honor. And as I was saying earlier, I think the reason why that is true, and it comports with traditional criminal law principles, where under the model penal code on which my friend has been relying, recklessness is the default mens rea. And the reason why that is
exactly. Well, so I'm sorry to interrupt, but the point being that Leocal recognizes the distinction that's traditional, negligence out, recklessness and above per model penal code is usually considered more important, but you don't have to guess because you have Voisin, I guess, that draws that distinction. And so that's what I thought the distinction was between Leocal and Voisin, but as your brief said. The other thing I wanted to get to is the notice point has been raised here, and it seems to me that the notice in this kind of statute is a little bit different, but and this is more of a comment, and you can fill in the gaps of it, but we're not talking about notice for committing reckless assault under Tennessee law. What we're talking about is someone who's been convicted 3 times for separate offenses under Tennessee law or other state law, who then, after being convicted of 3 violent felonies, knowing they shouldn't possess firearms, nonetheless possesses firearms on notice that they shouldn't possess firearms because they've been convicted of these prior offenses. So you actually have to 4 times have committed some pretty significant violation before you fall into this statute. Is that, I mean, that's my understanding, and I think that's an important point on notice, but you can elaborate if you wish.
Your Honor, I think that's exactly right, and I think it's another point I would emphasize here is, of course, the defendant knows if he has at least 1 conviction, he is undertaking a criminal act, and so I think he is clearly sufficiently on notice here, and I think the court has understood this phrase, use of physical force against the person of another, to encompass the type of reckless conduct that we're talking about here. I think one example is the court's own recent decision in Stokeling. Stokeling recognized that a typical robbery offense involving a struggle for an item satisfies the elements clause. Now, we wouldn't really say that the force applied by a victim pulling on one end of a suitcase is targeted, the force applied by a defendant pulling on one end of a suitcase is targeted at the victim who's pulling on the other end, as opposed to being targeted at the suitcase itself. But Stokeling's holding reflects that the offense nevertheless involves the use of force against the person of another because the defendant's force acts against the victim. That's the way Congress meant the language. That's the way the court understood it in Stokeling, and I think it provides a person who understands English with fair notice of what's covered here, just like page 2282 of the court's decision in Boycine does.
Thank you, counsel. Justice Barrett?
Good morning, Mr. Fagan. I have a question about the language attempted or threatened. So, the statute, to qualify as a crime of violence, must have as an element the use, attempted use, or threatened use of physical force, suggesting that the kind of use of physical force is the kind that can be attempted or threatened. Does that have any significance here? Do those terms, attempted and threatened, make sense when applied to reckless conduct?
Your Honor, I think traditionally under the criminal law, you can have an attempt to commit a crime with recklessness. The elements of the attempt crime and the mens rea for the attempt crime are going to look somewhat different than the crime that actually achieves its completed results. But I don't see any reason why, and they haven't really given any reason why, the mens rea for all three of these things has to track one another. And even if it did, threatening doesn't actually require intent to use force. A simple bluff would suffice in those circumstances. I also think it'd be quite anomalous to include crimes that involve only the threatened use of force, like bluffs, or the attempted use of force that the criminal law and the sentencing guidelines traditionally treat as less culpable as ACCA predicates, but not cases in which someone has actually injured someone in knowing disregard of a substantial and unjustifiable risk of doing so in gross deviation from the standard of conduct that an ordinary person would follow under those circumstances. A defendant who has, sorry.
I was going to ask you a question about Johnson and vagueness. So, one of the amici argues that including recklessness in ACCA is going to drag us into some of the same problems that we had under the residual clause, and this is picking up a thread that you started to touch on earlier. Is that true, in requiring courts to try to gauge what it means to pose a conscious disregard of a known risk? How risky is the risk?
Well, Your Honor, I really don't think so, because we're just talking about the standard definition of recklessness. It's the exact same inquiry that courts are already doing under Boycine, and that courts adopting our interpretation of the ACCA appear to have no difficulty doing. And I'd also emphasize something this court said at the end of Quarles, which is that at the end of the Quarles opinion, it makes clear that what's really required under the Taylor categorical approach is some kind of rough correspondence, and that we don't look at these very minute curlicues of particular state laws. And so I think the combination of all those three things, in particular the practical evidence that there hasn't really been any problem with this, shows that there's really no practical concerns here.
Thank you, counsel.
A minute left, Mr. Fagan.
Thank you, Mr. Chief Justice. Even petitioner doesn't really believe that the ACCA's language requires targeting, or else he'd limit it solely to specific intent crimes, and he wouldn't include knowledge or be hedging about extreme recklessness. And this court should reject his gerrymandered constriction of the ACCA to exclude crimes involving recklessness. Harming someone by knowingly disregarding their physical safety is a serious crime. It forms the core of numerous aggravated assault, common law robbery, and murder offenses. And cutting those crimes out of the ACCA would defy both common sense and Congress's clear intent as expressed in the statutory text. All of those crimes involve physical force against the person of another, and Boycine holds that the word use encompasses recklessness. Petitioner doesn't challenge that holding, and the court should adhere to it. Thank you.
Thank you, counsel. 3 minutes for rebuttal. Mr. Shanmugam.
Thank you, Mr. Chief Justice. This case really boils down to one proposition. Our interpretation faithfully reconciles Leocal and Voisin, and the government's doesn't. As to the text, both in Leocal and Voisin, this court made clear that the word use is synonymous with active employment, and it would be very odd to say that someone recklessly, actively employs force against another person. And the government's effort today, for the first time in the case, to suggest that against the person of another modifies force and not use of force is simply grammatically incorrect. But more generally, the government's position is breathtakingly overbroad. The government itself today acknowledges that it would cover reckless driving, which a provision of the Immigration and Nationality Act, Section 1101H, treats as a discrete category from crimes of violence. And as to the legislative history, if Congress had wanted to cover every variant of robbery and assault, and there's no evidence to that effect, it surely would have enumerated those offenses. And it bears repeating that under our interpretation, intentional or knowing variants of those offenses would still be fully covered. The government's argument today really boils down to an argument that the court resolved in Voisin a question that it expressly left open, and that the court should effectively overrule Leocal, at least as to negligent offenses. In Castleman, this court already held that the statute at issue here and the statute at issue in Voisin should be construed differently in light of their different contexts. And it is deeply ironic that the government is here today saying that the two statutes should be construed the same way. In Voisin, the government included a 7-page section in its brief, 7 pages, arguing that the statute should be construed differently. Indeed, at oral argument in Begay, the lawyer for the government conceded that even reckless homicide would not qualify under the force clause. It's only been since the court's decision in Voisin that the government has been pushing the envelope and trying to do under the force clause what it can no longer do under the residual clause now that it has been invalidated. As this court has said time and again in its many ACCA cases, this is a recidivist statute that should be construed narrowly. If a defendant is not subject to the ACCA, he or she can still be subject to a sentence of up to 10 years in prison. And finally, this is the paradigmatic case for the rule of lenity, which Justice Kavanaugh applies in the sentencing context no less than it does in the substantive criminal context. Where every court of appeals has construed a statute one way for more than a decade, a defendant should not be subjected to a 15-year mandatory minimum based on a decision involving a different statute that the government itself said should be interpreted differently. The Court of Appeals interpretation rests entirely on an overreading of this court's decision in Voisin and an underreading of this court's decision in Leocal, and its judgment should be reversed.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.